last video, we discussed encryption and U.S. customs searches. This edition is going to focus on whether the Fifth Amendment's right against self-incrimination applies to the act of decrypting the contents of your computer. Before we get into a couple recent cases, let's look at the self-incrimination clause of the Fifth Amendment. It protects a person from being compelled in any criminal case to be a witness against himself. So what does that mean?
Exactly how much money did you earn in your time as a crack cocaine dealer?
I said there are so many amendments in the Constitution of the United States of America. I can only choose one. I can only choose one. I plead the fifth. I plead the fifth. 5, 1, 2, 3, 4, 5.
It means the government can't force you to testify against yourself. Now, you can't just go around refusing to testify left and right. There are 3 specific criteria to claim Fifth Amendment protection. Compulsion, the government forcing you through a court order of some type. Incrimination, the testimony would likely lead to your being charged with a crime. And a testimonial communication. And there's the catch. What qualifies as a testimonial communication? It's something that makes use of the contents of your mind and conveys a statement of fact. Now, that's a bit abstract. The classic example often cited by the courts is the difference between a key lock and a combination lock. The government can force you to turn over a key to open a key lock, but the government can't force you to reveal a combination, as it would be testimonial, using the contents of your mind and communicating a statement of fact. So, one would naturally conclude that since there's no physical key to unlock encrypted files, only a password, that it would benefit from Fifth Amendment protection. But courts are actually struggling with the issue. Plus, there's a second way the government can skirt the testimonial communication requirement. That's if the government already knew the information that they are seeking to compel could be incriminating. And it's this second method that came to play in 2 recent encryption cases. United States v. John Doe in the 11th Circuit Court of Appeals, and United States v. Frisco in a federal district court in Colorado. In Doe, the court ruled that the Fifth Amendment prevented the government from forcing Doe to decrypt the contents of several computers. In Frisco, the court ruled that Frisco could be forced to decrypt the information on a computer. Fifth Amendment, decryption, why the different decisions? As lawyers like to say, it depends. In Doe, the computers were encrypted with TrueCrypt, and the government couldn't tell if there was actually any data on the drives. Since the government couldn't provide any evidence as to the contents of the drives without Doe providing the password, the court held that it was a testimonial communication. But in Frisco, the laptop was found in her home and had her name on it. Plus, in a recorded call with her ex-husband and co-defendant, she stated that there was a laptop that investigators would need her help in opening. Because of this, the court held that there is little question here, but that the government knows of the existence and location of the computer's files. The fact that it does not know the specific content of any specific documents is not a barrier to production. The government likes to call this the foregone conclusion doctrine. The difference between Doe and Frisco was the government's knowledge of the existence and location of the computer's files. So what does this mean to you? If you encrypt something, you're probably doing it to keep it private and secure. So just as you wouldn't share the password for an encrypted drive, don't talk about the encrypted drive either. Don't talk to government officials. Don't talk to friends. There's only a very small subset of people in which you can have privileged communications. But that's for another episode. If you want more information, you can always check out associatesmind.com.